All rise. First District Court of Appeal is now in session. All who have business before this court draw near, give attention, and you shall be heard. May God save the United States, the great state of Florida, and this honorable court.
Please be seated. We have one case on the docket scheduled for oral argument this morning, the case of Atlantic Coast Conference versus Florida State University Board of Trustees. Counsel ready to proceed?
Yes, Your Honor.
You may approach, counsel.
Thank you.
Counsel, we will allocate 20 minutes per side for the oral argument. Would you like to reserve some time for rebuttal?
I'm going to try to keep 5 minutes, Your Honor.
So noted, Madam Clerk.
Thank you.
You may proceed, counsel.
May it please the court. Alan Lawson, on behalf of the Atlantic Coast Conference, with me is Sarah Motley Stone, the managing partner of the Charlotte, North Carolina office of Womble, Bond, Dickinson, also representing the ACC. The question presented in this case is whether the trial court departed from the essential requirements of the law, causing irreparable harm, when it denied the ACC's motion to stay FSU's Tallahassee lawsuit, which was filed after the ACC had served FSU with its lawsuit over the same two contracts. The law in this case, and I'm quoting from Royal Globe Insurance, is well established, that's the term that they used. It's the well-established law of Florida that where two courts have concurrent jurisdiction of a cause of action, the first court to exercise jurisdiction has the exclusive right to hear all issues or questions arising in the case. Siegel uses the term exclusive jurisdiction.
Well, but there's some exceptions or additions or something else, though, that can be considered from reliable restoration and a number of other cases. Do we need to first decide, does it have to be extraordinary? Does it have to be additional? Is that something that we need to figure out?
In this case, you really don't, but that is one of the four ways that the trial court departed from the essential requirements of the law, by finding that exceptional circumstances were not required, extraordinary circumstances were not required. And I'm going to go through the four ways that the trial court departed from the essential requirements of the law. First, I'm going to briefly touch on irreparable harm because it's jurisdictional and because FSU argues that it doesn't exist in this case. In reliable restoration, you correctly held that the possibility of inconsistent rulings on the same legal issues from two different courts constitutes irreparable harm. And every case in Florida agrees with you. Every case that has been cited to you, you won't find one that disagrees on that point. There are other reasons that are also given for why it's irreparable harm, including the fact that and Siegel says this, the fact that you have to suffer two lawsuits over the same thing at the same time is harassing, it's oppressive, it's vexatious, and that alone is irreparable harm. Most of the cases in this area don't even talk about that jurisdictional requirement because it's so well established. So there's no question about your jurisdiction in this case, despite FSU's argument. And I would suggest that the departure from the essential requirements of the law is just as clear in this case. There are essentially two ways that you can depart from the essential requirements of the law. You can get clearly established law wrong, or you can base your ruling on factual circumstances that are not supported in the record. For example, if the trial court were to announce a rule that, although ordinarily the rule is that you're absolutely required to stay a case, a second filed case, that if it's served on Sunday, there's an exception for that.
But
And
Counsel,
goes on to find
you
that.
agree that additional or exceptional circumstances are a factor that the trial court can take in consideration in ruling on a motion to stay?
Absolutely. In the extraordinary case, the trial court can refuse the stay.
Do you agree that undue delay is not the only additional or exceptional circumstance that a court can take into consideration in ruling on a motion for a priority-based stay?
Yes. And I think it's important to look at the cases that did grant a stay or did uphold the denial of a stay. There aren't many in Florida because it is an extraordinary thing. Parker is one that's cited by the court itself. And I think that the key is that there is no case like this. There is no commercial dispute between sophisticated parties that has ever been determined to be extraordinary, containing extraordinary circumstances in the state of Florida. And so that's the starting point. The kind of cases that have been are family law cases, child custody cases, probate cases, with truly extraordinary circumstances. In Parker, the beneficiary had filed suit first and served it to probate the estate in Maryland, the state of Maryland. The personal representative had filed suit in Florida, where the deceased was living at the time of death, where the property was, that kind of thing. And the Maryland suit, nothing had happened. The will had not even been admitted to probate. In the Florida suit, the case had been ongoing, and the creditors had been notified, claims had been made, things were ongoing. And then in addition to that, the trial court looked at the case and determined that if the case were probated in Maryland, there would be significant adverse tax consequences to the estate, and said if you look at all of that, this is an extraordinary circumstance, we're not going to move from the rule.
But counsel, why should an anticipatory filing constitute an additional or exceptional circumstance.
Okay. And let me tell you that an anticipatory filing is a term of art that is used in the federal courts that are applying the federal declaratory judgment action. That same term of art is called procedural fencing under North Carolina law, which looks at this issue. And I can't tell you that that could not be considered in a case if it existed. What I can tell you is the record is clear that it did not happen here. Let me explain what that term of art means. What that term of art means is that you have a natural defendant who is trying to avoid legal responsibility for otherwise valid legal obligations. And that natural defendant, and it happens a lot in the patent context where someone will use, a patent troll will use someone's patent and have a product that they're using. They'll get a cease and desist letter and say, stop using, and they'll string the patent holder along. And then finally the patent holder says, listen, I'm going to file suit if you don't do X, Y, or Z. And then that natural defendant files suit in order to deprive a natural plaintiff from its choice of forum. Because you've got to remember that in Florida and North Carolina and every other state, the general rule is that a plaintiff is entitled to choose its forum.
But there are several federal cases on anticipatory filing, is that correct?
That's right. And what they say is...
Why should we disregard those federal cases? That anticipatory filing is an exception to the first to file rule.
So, as it says in all the cases, that the reason given has to be supported by the record. And the reason why you could not uphold the trial court based on its finding that anticipatory filing was a valid basis to refuse to apply the rule of priority in Florida is because it does not exist here.
Well, doesn't Dr. Ryan's declaration, though, establish that this was an anticipatory filing?
No, what it establishes is that the ACC is a natural plaintiff, and let me just back up and talk about the North Carolina Grant of Rights Agreement, because that's one of the two agreements, the two North Carolina contracts that FSU has violated, okay? So in that agreement, FSU promises, and it's a multi-party agreement, it's not just FSU. It's FSU, every member institution, and they all signed a contract with the ACC that said that they would transfer these intellectual property rights, broadcast rights, copyrights, other intellectual property rights to the ACC so that they could be bundled and sold to ESPN. It is normal when you do that you would make that an irrevocable agreement because you can't revoke it and the other party is depending on that. And as part of that, there's another clause, and it's at page 489 of the record, paragraph 6 of the Grant of Rights Agreement. FSU and each member promised that they would not take any action that would affect the validity and enforcement of the rights granted to the conference under this agreement. So when the board met on December 22nd, it voted to violate the Grant of Rights Agreement. And in reaction to that, the ACC filed suit.
Well, and that's a question I'd like for you to
Yes.
address, the material litigation aspect. So to me, the core facts of us applying correctly the principle of priority is what's the first filing. So I understand the sort of, and I'm going to use the word tenuous position that you're in, where you have a filing without ratification of 2/3 of the ACC per the Constitution, the first filing by the ACC. You concede, well, we filed that and it's not material litigation, therefore we didn't have to have that ratification. FSU then files an all-encompassing complaint, and then you ACC, file an amended all-encompassing complaint, and then you want to argue sort of the privilege or enjoyment of a reversion back to the first filing, which you've conceded is not material litigation. Right. So I'm having a problem with that, if you can address that, please.
Absolutely. So first of all, the rule of law is in which court did jurisdiction attach first, and that's related to service. It's not related to filing at all. And the question is whether the North Carolina court had jurisdiction first, they did, and whether they properly maintained it. When it comes to issues regarding the propriety of the North Carolina court exercising that jurisdiction, the law in Florida is clear that that is not a proper consideration in the principal priority at all. Those are issues that are exclusive to the North Carolina court. And that is Toth, Morrison, Byrne, and Williams. That applies to the sovereign immunity argument, which, as everyone knows, if you enter a contract in Florida, you waive sovereign immunity. What we're talking about is jurisdictional immunity. Can FSU be sued in the North Carolina court? And that actually was the trial court's consideration of that is not allowed under Florida law. FSU's only recourse for the trial court's finding that sovereign immunity or immunity was waived, and all of these other issues that go to the jurisdiction of the North Carolina court, the only recourse that FSU has is to appeal that, which they have to the North Carolina Supreme Court. So those are not proper considerations. And in Morrison, it says, questions regarding the out-of-state court's jurisdiction do not bear on this court's decision that the principal priority applies. So if you can, and of course FSU moved to dismiss on those grounds and argued all of those things under North Carolina law to the trial judge, and the trial judge's well-reasoned 70-page order is in the record, and he found that that did not affect jurisdiction. And it certainly is not something that, without conflicting with Morrison, can be considered here.
It's the fact that FSU is an entity of the state of Florida, and we have the Sunshine Law, open records, open meetings, have any impact on the principle of priority as related to some other entity? Because basically it seems to me, given that you've got to have an open meeting, you've got to have a vote before a state entity can sue, anybody can get the jump on a Florida city, county, university from an out-of-state perspective. So there's always going to be priority if somebody is diligent watching what the in-state entity is doing.
Right, and so I think the way I would view it is that if you had procedural fencing, the term of art, if you had an anticipatory filing and somebody got the jump on a Florida entity, you could then use that to determine that it would not be appropriate to give priority to the out-of-state case. Again, that is not what happened here. If you look at page 850 of the record, page 69 of Judge Bledsoe's North Carolina order, he says that, okay, this concept, and it's the same one in both areas, procedural fencing, anticipatory filing, occurs when a potential defendant anticipates litigation by the natural plaintiff in a controversy and files first in order to deny a natural plaintiff its choice of forum. FSU has breached its contract with the ACC and all member institutions when it challenged the grant of rights agreement. That agreement, by its express terms, is irrevocable, and they promised that they wouldn't challenge it during the term of the contract, which with the amendment is until 2036. They've also breached the ACC Constitution. The ACC is a natural plaintiff, and that's what Judge Bledsoe found. The FSU Board's argument hinges...
The anticipatory filing issue.
Yes.
Aside from the Rush case, which you cite in your brief, which did not expressly mention anticipatory filings, what authority tells us that the trial court departed from the essential requirements of the law in this case?
The trial court, with respect to the finding that the ACC was engaged in improper forum shopping, the departure from the essential requirements of the law was not considering that issue. The departure from the essential requirements of law was finding forum shopping where it doesn't exist. It just doesn't exist on this record. In fact, FSU is akin to the patent troll. What they were trying to do was attempting to abide by the spirit and the letter of the Sunshine Law and public meetings laws in Florida by getting one over on the ACC and preventing them from getting their choice of forum, because they are a natural defendant. We're the only party that's suing for damages. FSU is not suing for damages. They're suing to say, let us out of our legal obligations, the contracts that we entered. So they're in the position of the patent troll. And it's because the facts are such that ACC is a natural plaintiff. The federal courts would not be applying its anticipatory filing rule because that's that term of art. That's not what it means. The same term of art, it's called procedural fencing under North Carolina law, where they do consider that. I'm not saying that it can't be considered in Florida. I'm saying that it doesn't exist on this record. The second way, and the hypo that I was going to give, if the trial court said that there's an exception for cases filed on or served on Sunday, and this case was served on Sunday, and so we're not going to apply the priority rule, and the record shows that it was served on Wednesday, then it doesn't matter what the law is. It's an abuse of discretion in order to refuse to stay. You're not respecting the principle of priority if you refuse to stay based on facts that are not true. There are three indicia.
Counsel, you're well into your rebuttal time.
Okay. Do you have any other questions at this point? Okay, I'll save the rest of my time for rebuttal.
Thank you, counsel.
Thank you.
However, we will extend your rebuttal time by an additional 3 minutes. It was extend counsel for the appellee's argument by an additional 3 minutes. You may proceed, counsel.
May it please the court, Elliot Shirker on behalf of the FSU Board of Trustees. The overarching question for this court is whether this exercise of discretion by this circuit judge, based on undisputed facts, to deny a stay of the FSU Board's Florida action was such an egregious abuse of a trial court's discretion as to warrant certiorari relief. We submit the answer must be no. The ACC's burden is to show that the factors upon which the trial court relied are forbidden factors under established Florida law. The ACC has not met and cannot possibly meet that burden, and therefore cannot be entitled to certiorari. As the case was presented to this court in the papers, and it's been a little bit different this morning, the ACC's position was that when the question is first whether a second filed action should be stayed, we don't need judges at all. We need computerized scanners that can look at the filing dates, and whichever case was filed first, the second case must be stayed.
But counsel, doesn't this case present the type of situation that the principle of priority was created to address? That is, where you have two ongoing lawsuits in different jurisdictions that could reach contrary outcomes.
That is the principle of priority, Your Honor, but the principle of priority as set forth in Siegel recognizes that a stay is never a matter of duty. It is a matter committed to a trial court's discretion. The court in Siegel, the extraordinary circumstance in Siegel was delay, which is one of the factors upon which the trial court relied here, but the court was very careful to say that there may be other additional circumstances that would warrant a denial of a stay by a trial court. There's no list set forth, and if there were, the other side here cannot tell you that the factors considered by the trial court were forbidden. As a matter of fact, I believe I heard Mr. Lawson say that they're not saying, at least not saying any longer, that it would be wrong as a matter of law to consider the anticipatory filing exception, which is well recognized in federal law. The Florida courts have not spoken to the issue. The case law recognizes that. And what the ACC is asking the court to do is to declare as a matter of law that anticipatory filing cannot be considered as a factor in determining whether to exercise discretion and deny a stay, and then to hold that because it cannot be a factor, there was a departure from the essential requirements of law. As we set forth in our response, the role of certiorari is never to create a new rule of law and then find that there was a departure from that new rule of law that would warrant certiorari relief. So the principal priority is not simply which case was filed first. That's what the ACC would like the law to be. The ACC tells this court, for example, that the trial court ignored the principle of priority. I believe that's almost a direct quote. The principle of priority is discussed for the first time in the first page of the trial court's order with a citation to Siegel. The court recognized what the principle of priority is and looked to the undisputed facts as set forth initially in Chairman Ryan's declaration that the action was only filed when the ACC knew, as a result of Florida public meetings rules, that FSU was going to file an action. And the ACC moved so rapidly, and this is a factor on which the trial court relied, Judge Thomas, the ACC moved so rapidly that it didn't follow its own rules for the initiation of litigation. The trial court said that it would not rule on whether that was ultra-virus.
Is it appropriate for us to consider those things, whether the two-thirds vote was present, the sovereign immunity issue, those kind of issues? Is it appropriate for the trial court to consider that, and is it appropriate for us to consider that?
Absolutely, yes, Your Honor.
And then, so the additional question to that then, is it also then appropriate to consider the merits of FSU's lawsuit here, if we're considering their defenses to the North Carolina lawsuit?
The trial court did not address the merits of a defense or the merits of the claims, and was very careful to say that there were certain matters that were presented in the state litigation that were much more appropriate for summary judgment. So the court wasn't a question of whether the court determined that there was a violation of the ACC's rules. What the court said was that the fact that the ACC didn't follow its own rules is a factor to be considered in determining whether the ACC was jumping the gun and filing it and it was engaging in an anticipatory filing. That was a sub-factor in the court's consideration of anticipatory filing. The point is, the key point is this. If, as I believe I heard Mr. Lawson say this morning, which is a bit of a departure from the papers, that anticipatory filing is a factor that a Florida judge can consider, then they're reduced to asking this court to determine as a matter of fact that there was no anticipatory filing. Now, that somehow got wrapped into the concept of exclusive jurisdiction in the first filed court, which has nothing to do with the issues here. The question is not which court has jurisdiction. This is not a matter of issuing an injunction against a court that's proceeding without jurisdiction. The question is, and this is purely a question for the so-called second filed court, because that's the court that decides whether to grant a stay. It's not for the first filed court to determine that the second filed action cannot go forward. A court in North Carolina cannot prohibit an action in Florida from going forward. That's a matter for the Florida trial judge under Siegel. And what the second filed court is charged with determining is whether there are exceptional circumstances or additional factors or extraordinary circumstances. Those are all from Siegel in various different paragraphs. Would warrant the exercise of discretion to not stay the litigation. And we recognize, as Siegel holds, that there are situations in which parallel actions will be allowed to go forward if a Florida judge determines in the exercise of discretion that there are factors that warrant allowing the second filed action to go forward. And
in that case, counsel, in that case, if both suits are allowed to proceed and if both result in different outcomes, what happens then?
Well, Your Honor, the possibility of conflicting decisions is the basis for the principle of priority. That's true. But if a trial court in Florida has discretion, which Siegel establishes, to allow the second filed action to go forward, then the possibility of inconsistent results is not a per se basis for the grant of a stay. If that were the rule, then the question would simply be which action was filed first, period, end of inquiry. And Siegel teaches us that is not the case. And as the third district recognized more recently in the Sanchez case, Siegel did not cabin the factors that can be considered in determining whether a stay should be granted. This is quintessentially an exercise of judicial discretion by a circuit judge to determine whether the facts and circumstances of an individual case are such that a second filed action should be allowed to proceed.
I don't think that there's a dispute, maybe there is, you can correct me if I'm wrong, that the actions are substantially similar. One of the considerations, would you agree that they're substantially similar?
Under the broad definition of substantially similar for this purpose is yes, Your Honor.
Given then that they are substantially similar, isn't the ACC the natural plaintiff and should be allowed to proceed with its suit?
No, Your Honor. The claim, FSU's claim, as set forth in the second amended complaint, which is the operative complaint in this case, is based on the ACC's position that it can continue to own the rights to FSU's home games after FSU leaves the ACC. That they can take quintessentially Florida property, Florida sovereign property, and use it until, I believe, 2036. And the FSU's position is, no, you can't do that. You can't take our Florida property, much less in a North Carolina action. And that's the gravamen of FSU's position in its proceeding. And that is, to me, a natural plaintiff if there ever was one. Now, what the ACC is trying to do is, when its action is originally filed, was to stop FSU from going forward in state court. That's exactly what they've said in all the proceedings in North Carolina and here. So they were trying to stop a plaintiff from going forward in the plaintiff's chosen forum by bringing the action in North Carolina.
So do you concede that the declaratory judgment filing, the first filing by ACC triggers, qualifies as a first filing or not?
It was filed first, Your Honor.
And do you concede that it's substantially similar, such
As-
that that qualifies as a first, filing?
Yes, Your Honor, and that's what triggers the principle of priority, which the trial court very faithfully applied as set forth in Siegel and subsequent cases, yes. But the principle of priority is never a matter of duty. It is never a
I
per se rule.
understand that. I'm talking about the substance of the suit.
Yes, Your
With
Honor.
their concession that the first filing is not material litigation, the amended complaint encompassed all of the claims that FSU's suit filed. So I'm trying to understand your position. If you're conceding that the declaratory judgment that was filed first qualifies here as a first filing, or are you arguing that it really shouldn't? It doesn't qualify as a first filing. It wasn't material litigation. It doesn't check the box of substantially the same litigation.
No, Your Honor. The reason that we talk about it not being material litigation, and the reason that Judge Cooper relied on that factor, was in the context of applying the anticipatory filing exception. Is that there was such a rush to the courthouse by the ACC that it didn't even follow its own rules.
So it's your position that's only relevant to anticipatory filing?
That's how Judge Cooper applied it, Your Honor.
With regards to Judge Cooper's findings regarding anticipatory filing, is there any Florida authority that says that that anticipatory suits constitute an additional, exceptional, extraordinary, or special circumstance for purposes of a priority-based suit?
The Florida court, no published Florida appellate decision has addressed anticipatory filing. The trial court looked to parallel provisions of federal law, which, Your Honor, is hardly unusual when Florida courts are interpreting rules of civil procedure or rules of evidence that are taken from the federal rules. It's very common to look to parallel federal law to determine the meaning of a Florida rule. So here we have a principle of priority in Florida, which is almost exactly the same as the rule in federal court, and the court looked to federal case law for guidance. That's to me is the essence of a trial court's discretion in trying to determine how to apply the law to the facts of the case. And what Siegel teaches, and what every subsequent case to address it says, is that Florida has not cabined the list of extraordinary circumstances or the list of additional factors that a trial court can consider. So it is and as I said, I believe I heard Mr. Lawson say this morning, he is no longer contending that a Florida court cannot consider anticipatory filing. He says that there was no factual basis for it. That doesn't sound very much like a departure from the essential requirements of law if we're quibbling about the trial court's weighing of facts. But more to the point, the facts are undisputed. They're set forth in the Ryan Declaration. The only reason this action was filed was because FSU had followed Florida law and signaled that it was going to file a lawsuit in Florida. What's missing from the ACC's analysis is the ACC could have brought its action in Florida. The ACC could still bring its claims in Florida. Nothing prevented it from doing so. Instead, what the ACC did was to bring the claims in North Carolina, which triggered the question whether the waiver of sovereign immunity in Florida statutes applies to actions brought against Florida sovereign entities in another state, led to protracted litigation in the North Carolina trial court and an automatic right of appeal and an automatic stay pending that appeal in North Carolina. The North Carolina action is not moving forward until that appeal is resolved. And that's something you see in Judge Cooper's order as well. And that tells us two things. That tells us, one, that Judge Cooper relied on a factor expressly authorized and applied in Siegel. That is, the delay that's caused by moving a sovereign immunity question under Florida law to the North Carolina court. It also tells us something about irreparable injury. Now, you heard the other side say, well, we have per se irreparable injury in these cases because you've got a possibility of inconsistent rulings, and there are cases that say that. But we also have here the question whether it is appropriate for a North Carolina court to be deciding a question of Florida sovereign immunity and the disposition of Florida sovereign property. And Judge Cooper also relied on those factors as extraordinary circumstances unique to this case and as additional factors under Siegel. The fundamental question remains, as I said. When the ACC says the trial court, and it says that this is page 1 of its reply, when the ACC says the trial court abused its discretion because the court, quote, refused to apply the principal priority at all, the ACC is wrong. The trial court clearly applied the principal priority, and I don't think that's really open to dispute any longer. The principal priority, Judge Thomas, quoting from Siegel, allows a court of one state in its discretion to stay a proceeding in deference to an action in another state. Stated otherwise again from Siegel, if I might, a trial court is not always required to stay proceedings when prior proceedings involving the same issues and the same parties are pending before a court in another jurisdiction. Wrapped into that determination are the additional factors or circumstances set forth in Siegel. And those circumstances are not cabined under Florida law. The Florida Supreme Court entrusted the trial courts in this state to take into account the circumstances of each case in determining whether to grant priority. Most notably, we submit no error worthy of consideration on certiorari was committed by the trial court in the factors that it considered. And what were those factors? The court considered the anticipatory filing based on undisputed facts. By the ACC, the court considered that these are questions of Florida sovereign immunity that were brought before a North Carolina court when the ACC's claim could have been brought in Florida and could still be brought in Florida, where there is a waiver of sovereign immunity. And we have Florida sovereign property before being disposed of, if you will, before a court in a foreign state, and we have the delay that's occasioned by the Florida sovereign immunity issue having been raised in North Carolina. Now, in what I would call an act of projection, the ACC argues that, well, it's FSU's fault that there's delay in North Carolina. Your Honors, we are defending ourselves in North Carolina against the lawsuit and exercising our Florida sovereign immunity rights that hardly can be laid at our doorstep, whereas the delay that could be occasioned here very much should be laid at the ACC's doorstep. This case is proceeding apace in the trial court. The trial court lifted the stay of discovery, denied a motion to dismiss by the ACC for lack of personal jurisdiction. The ACC tells this court that it's going to take an appeal of that ruling to this court. Regardless, the case is going forward in the circuit court at full tilt, if you will. To make the Florida court wait for the disposition of an issue that the ACC created by bringing its action in North Carolina and thereby teeing up the question of Florida sovereign immunity in North Carolina, to make a Florida court considering a claim by a Florida sovereign entity for the taking of its property by the ACC would be an inappropriate exercise of a trial court's discretion under any circumstances and in any event. It cannot be such an abuse of discretion as to warrant relief on certiorari.
Counsel, going back to my question again, if both lawsuits are allowed to proceed and ultimately reach different results, what happens then?
Your Honor, I don't have an answer to that speculative possibility because we don't know what will be decided in North Carolina and we don't know what will be decided in Florida. What I can say with full confidence is that possibility is recognized by Siegel as permissible when there are extraordinary circumstances or additional factors or exceptional circumstances, pick the verbiage, that would warrant the Florida case going forward. That's baked into the law on the principle of priority in Florida, there is such a possibility. On the other side, you have a speculative possibility of differing results at the end of the case. And that's all you have. So I'm comfortable in the position that we've taken, Your Honor, that that possibility standing alone doesn't trump exceptional circumstances in a given case, or Siegel would make no sense. At the end of the day, the question whether to grant a stay is committed to a trial court's discretion. Certiorari relief is only available if there is such an abuse of that discretion as to constitute a departure from the essential requirements of law. You've heard a concession this morning that there's no legal error in the factors that the trial court considered. And as a matter of fact, one of those factors, delay, is out of Siegel itself. So there's clearly no legal error there, much less a departure from the essential requirements of law. What they are asking you to do now, as I understand the argument I heard this morning, is to step into the shoes of the trial court and weigh the facts on anticipatory filing to determine if that factor was appropriately considered by the trial court. That is antithetical to this court's role on certiorari, and they shouldn't even be heard to make that argument. We request the court to deny the petition. Thank you.
Thank you, counsel.
Thank you, Your Honor. I first want to talk about the legal error that the trial court made. On page 2 of its order, it says that under Florida law, you don't have to find extraordinary circumstances.
But then it goes on to say, but there are extraordinary circumstances here nonetheless, right? So, I mean, what's that matter?
It matters because the concept that's being pitched to you is that there's just this discretion in this area. And where that comes from is in Siegel, the Supreme Court quoted Bedingfield from the 4th DCA, a much earlier case, that quoted an Amjur article that says, in general, when you're talking about actions between states, in this issue, there is discretion for a trial court to stay an action and let an action in another state go forward. That is not talking about broad discretion under Florida's principle of priority. Under Florida's principle of priority, the appellate courts have routinely said that a trial court abuses its discretion if it fails to follow the rule and stay the action unless the case is extraordinary. As Siegel says, the ordinary rule is that you stay the case. In Siegel, it was argued that there was delay, and the trial court said, but this isn't extraordinary, and they quashed the decision of the trial court that refused the stay.
How do you respond to the argument that the North Carolina action being stayed pending appeal, there is delay, therefore there is extraordinary circumstances?
It's not extraordinary. Okay,
extraordinary circumstances.
It's not an extraordinary delay. It's a normal delay. And to answer your question, Judge Lewis, if you want to talk about delay in resolving this dispute, what happens if there are inconsistent rulings after all of the appeals, a final judgment, then there's additional litigation in which we find out which judgment isn't worth the paper that it's written on. So under the full faith and credit clause of the United States Constitution, If there are competing judgments, then you have further litigation to see which one is enforceable. And so the normal delay in a commercial case, because there's a cert appeal or a direct appeal of a preliminary decision, is not extraordinary, and it's not the kind of delay that would warrant even thinking about in this context, is my answer to that
Their argument is
question.
that, the issue of potential sovereign immunity and property interest is an extraordinary circumstance. Can you address that?
I absolutely can, and that's been addressed already under Florida law. Under the full faith and credit clause, the sovereign immunity decision of the court that has jurisdiction to hear that, that's not an issue in this case. As Burns said, the Florida Supreme Court, it would be a strange rule of law indeed for one court to be able to rule on another court's jurisdiction. The Circuit Court in Leon County has no jurisdiction to rule on issues about whether the North Carolina court is properly exercising its jurisdiction, including the sovereign immunity argument. And let me just quote from Toth in the first DCA: "An objection to the foreign court's jurisdiction is not a proper basis for refusing to apply the principal priority." That's not a quote. This is a quote. "Respondent's route for seeking relief from the order of the Pennsylvania trial court's determination that it had jurisdiction was through the Pennsylvania appellate process, not through a later filed Florida action." So the law is clear in Morrison, and this is a quote, "Questions regarding the out-of-state court's jurisdiction do not bear on a Florida court's decision that the principle of priority applies." As a matter of law, it was a departure from the essential requirements of the law to consider that at all. Any issue relating to whether the North Carolina court has jurisdiction is an issue that is for the North Carolina court later. If it ever gets to federal court, the federal courts would say the Florida court is required to follow whatever the North Carolina court says regarding its jurisdiction. It's not an issue at law. I also want to talk about the fact that there is nothing extraordinary and nothing nefarious about the timing of the ACC's lawsuit or the forum that it chose. Remember, the general rule is that a plaintiff is entitled to its choice of forum. And this notion that there is a takings case in North Carolina, the characterization, I would say, is extraordinary. It's not an extraordinary circumstance. If you want to see what this case is about, all you need to do is look at 2 pages of the record, page 488 and 489. That's the ACC, Atlantic Coast Conference Grant of Rights Agreement. It's only 3.5 pages long. The rest are all the signatories from all the parties to this agreement, okay? In paragraph 1, each member hereby irrevocably and exclusively grants to the ACC during the term of this agreement, and that's until 2036 with the amendment, all rights necessary for the conference to perform its contractual obligations under the ESPN agreement, and then there are other copyright and other intellectual property rights that are given. We're not talking about property in Tallahassee, taking property in Tallahassee. This is a document that was signed by every member institution. So home games at Duke, home games at Notre Dame, home games across the country. And let me just ask, if you were to ask the question, what is the most appropriate, natural, and convenient forum for a dispute over a North Carolina media rights contract involving intangible intellectual property rights with signatories from 9 states whose sole situs of common connection is North Carolina, the home of their common enterprise to which they regularly travel to conduct the business of that organization that they joined, that was formed and operates under North Carolina law, you have to be wearing garnet and gold colored lenses to come up with Tallahassee as the answer for the most natural place for that contract dispute. And when it comes to, I'll give you one more page of the record, and that is page...
Counsel, your time has expired, but I will allow you to wrap up.
Page 850 of the record is Judge Bledsoe's determination of this whole anticipatory filing concept. And what he said is what's true, is that the ACC, it was only natural and ordinary that it would file in its home forum when it could, and under North Carolina law, it could not file suit until FSU's breach was imminent.
Thank you.
It had to be a practical certainty, and that was made clear when FSU noticed its meeting to breach. Thank you.
Thank you, counsel, for your respectful oral arguments this morning. This concludes our oral argument for this morning. We are adjourned.
All rise.